Imagine waking up, right? You pour your morning coffee, you walk out to your mailbox, and you find a single sheet of paper that just completely shatters your reality.
Oh man. Yeah, that's a nightmare scenario for anyone.
It really is. You open it, and it's from the government, basically telling you that your refugee claim is suddenly ineligible.
Yeah.
And then you look closer at the date on this letter, and you realize a clock has already started ticking.
Right. And it's a very fast clock.
Exactly. You have exactly 15 days to save your entire future.
It's just an incredibly jarring scenario. And, for tens of thousands of people, that ticking clock is not just some hypothetical thought experiment.
No, not at all.
It's an immediate, terrifying reality that dictates literally every move they make next.
And that terrifying 15-day countdown, it's exactly what we're looking at today. Because we've gotten our hands on a stack of leaked, highly detailed internal playbooks from May 2026.
Yeah, these are fascinating documents.
They really are. They're meant for the eyes of legal teams only. So we're talking procedural guides, paralegal handbooks, operational security manuals.
The behind-the-scenes stuff.
Right. And they were written for lawyers who are trying to navigate the immense fallout of a piece of legislation known as Bill C-12.
So just to give you some quick context on the landscape these lawyers are operating in, Bill C-12 introduced very strict bars for refugee claimants in Canada.
Right. The new rules.
Yeah. There's a 1-year bar, meaning you basically cannot make a claim if more than a year has passed since your first entry into the country.
Wow. Okay, so if you wait a year and a day, you're out.
Exactly. And on top of that, there's a 14-day bar for people who cross between official ports of entry. So this legislation effectively disqualified roughly 30,000 asylum seekers almost overnight.
That is just 30,000 people. That's a massive scale. Now, before we go any further, I want to be crystal clear with you, the listener. We are maintaining absolute political neutrality on this deep dive today.
Yes, very important point.
We are not taking a stance on Bill C-12 itself, whether it's right, wrong, necessary for border security, or like unfair to migrants. That's not what we're doing. Our focus today is strictly on the strategic chess game outlined in these leaked legal manuals.
Right. We want to understand how the justice system actually functions behind closed doors when a high-volume crisis like this hits.
Because it is a crisis for these legal teams. So we're going to break down how they manage a bottleneck of this scale.
And it is this incredible, almost contradictory combination of high-level constitutional theory and very grounded, gritty, bureaucratic survival tactics.
Yeah, survival is the right word.
It really is. And we'll be looking specifically at how they manage this for extremely high-risk clients, particularly Iranian nationals.
Okay, let's unpack this, because when you hear that a single law has impacted 30,000 people, the sheer logistics of that are just, they're mind-boggling.
Yeah, completely.
You obviously cannot fight 30,000 separate individual constitutional wars in the federal court.
Mm-hmm.
I mean, the entire judicial system would just completely collapse under the weight of the paperwork.
It would instantly grind to a halt, yeah.
So there has to be an overarching battlefield strategy to process this volume.
There is, and the internal strategy guide actually maps it out brilliantly. It relies on a 2-layer attack.
Okay, 2 layers. Walk me through that.
So when a lawyer files the initial challenge for a client, which is formerly called an application for leave and for judicial review, or ALJR, if you want the acronym.
Right, it's the ALJR.
Yeah. They don't just throw their biggest, heaviest argument at the judge right away. They plead 2 alternative grounds. Ground 1 is the primary attack, and ground 2 is the constitutional backup.
Okay, I actually noticed this in the manual. Ground 1 isn't about human rights at all, which surprised me.
Yeah, it's super technical.
It is. It's based on a Supreme Court case called Vavilov, which is purely an administrative law argument. You're basically telling the judge, hey, let's ignore the big picture of Bill C-12 for a second. The specific immigration officer who processed my client's file simply made an unreasonable decision. Like, maybe they didn't read our submissions correctly, or they checked the wrong box.
Yes, precisely. It is a highly localized procedural attack. And the thing is, if you win on that Vavilov ground, your client's specific refusal is just tossed out.
Oh, really?
Yeah, and their case goes straight to the Refugee Protection Division for a normal hearing.
But wait, I have a question about that. If the ultimate goal of these legal teams is to strike down Bill C-12 completely, why bother arguing about whether one specific officer checked the wrong box?
Well,
Isn't that just generating extra paperwork for a court system that, is already overwhelmed? If you want to argue the law itself is unconstitutional under the Charter of Rights and Freedoms, which is that second ground, Why not just lead with that massive haymaker and save everyone the time?
I know it sounds counterintuitive, but what's fascinating here is how this two-layer approach actually creates a strategic safety net. And they use a mechanism called abeyance.
Abeyance. Okay, how does that work?
So if you file a genuine, strong Vavilov argument, the judge has to look at that first. If you win, great, your client gets their hearing. But if you lose, like if the judge says, no, the officer did everything perfectly according to the letter of this new law, that is where the second layer kicks in.
Okay.
You basically pivot and say, well, okay, if the officer applied the law correctly, then the law itself violates sections 7 and 15 of the charter.
Right, but the paralegal managing this file doesn't actually want to fight a massive charter case for all 30,000 clients individually, do they?
No, God, no. And here's the genius part. You don't argue that massive constitutional case yourself. Instead, you ask the court to hold your client's file in abeyance.
Oh, I see.
Yeah, you effectively pause the legal clock. You tuck your client's file safely behind a few massive lead test cases that are being fought, funded, and managed by these heavyweight organizations.
Like the Canadian Association of Refugee Lawyers, right?
Exactly.
Ah, okay. So it's like you're drafting behind a semi-truck on the highway.
Yes, that's a great analogy.
You let the big organizations take all the wind resistance, pay the massive legal fees, recruit all the constitutional experts, and your client, who's just waiting quietly in the back seat in abeyance, gets to ride their slipstream.
Exactly. You're completely shielded.
And if the semi-truck reaches the destination and actually gets the law struck down, your client benefits from that victory without having fired a single shot in the constitutional war.
Precisely. You let the lead cases drive the outcome. But, and this is a big but, the strategy relies heavily on the specific nationality of the client, which is why the manual focuses so intensely on Iranian nationals.
Why them specifically?
Because Iran is currently designated as an ADR country, meaning administrative deferral of removal.
Okay, so basically the Canadian government officially recognizes that the situation on the ground in Iran is far too dangerous to deport people back to.
Correct. So even if an Iranian client's refugee claim is deemed ineligible under Bill C-12, the border agency cannot legally put them on a commercial flight to Tehran.
Oh, wow. I see where this is going.
Yeah, and that makes the abeyance strategy incredibly potent for them. I mean, a massive constitutional challenge moving all the way up to the Supreme Court of Canada, that can easily take 4 to 7 years to resolve.
Right. And most people would be deported long before that finishes.
Exactly. But because Iranian clients are protected by that ADR designation, they can sit in that legal waiting room for 7 years without the imminent terror of being deported tomorrow.
Wow. They are perfectly insulated while the constitutional war rages on above them.
Yeah. It's a very specific, very effective shield.
Okay, so the overarching strategy is brilliant. I'll give them that. But pulling it off, that is a completely different story. Let's zoom out of the constitutional theory for a second and look at the actual mud these legal teams are trudging through.
Oh, the mud is deep.
Because the logistics described in these handbooks sound like an absolute bureaucratic nightmare. Let's go back to that ticking clock we talked about at the very beginning of the deep dive. The 15-day bomb.
Right. The 15-day bomb is the foundation of everything. From the exact moment the client is notified that their claim is ineligible, the lawyer has 15 calendar days to draft and file that ALJR in federal court.
Calendar days, not business days.
Calendar days, weekends count. And the manual repeatedly capitalizes the word strict when discussing this deadline. It is jurisdictional.
Meaning what exactly?
Meaning, if you try to file on day 16, the court registry will literally reject the paperwork. They won't even look at it. The door slams shut.
And if that door slams shut, your client is in severe jeopardy. They just lose their right to challenge the decision entirely.
Yep. And their only real fallback at that point is filing something called a humanitarian and compassionate application.
Which, sounds lovely in theory, but the handbook explicitly note those H&C applications are drowning in backlogs.
Oh, they are a mess.
We're talking backlogs that can take up to 10 years to process. You absolutely do not want your client stuck in a decade-long queue just because you missed a courier deadline.
You really don't. And if you do manage to survive that initial 15-day LOM, you just trigger the next phase of the gauntlet.
Of course.
You send a formal request, a Rule 9 letter, asking the government for the officer's written reasons for the refusal. And once the government actually hands over those reasons, a new countdown begins.
Here we go again.
Yep. You have exactly 75 days to perfect the application.
Perfecting it. Meaning you're compiling the entire case.
Yeah, drafting the affidavits, gathering all the evidence, writing the complex legal memorandum.
Putting it all in a massive, meticulously formatted binder and filing it with the court.
Exactly.
But buried inside this 75-day perfection stage is a procedural requirement that genuinely stressed me out just reading it.
Let me guess. The NCQ.
Yes. The Notice of Constitutional Question.
Yeah, the NCQ is perhaps the most rigid, unforgiving technical requirement in all of Canadian constitutional law.
Honestly, reading the instructions for it reminded me of one of those terrible video game escort missions.
Oh my God, yeah.
You know the ones I mean, where the game forces you to deliver physical invitations to like 14 different castles spread across the map. And if you drop even one invitation or deliver to the wrong castle, the game abruptly ends and you lose all your progress.
That is a remarkably accurate way to visualize it, because under Section 57 of the Federal Courts Act, if you want a judge to declare any federal law unconstitutional, you cannot just tell the judge and the federal government.
Right.
You are legally required to formally serve the Attorney General of Canada, plus the Attorneys General of all 10 provinces and all 3 territories.
14 bosses. You literally have to serve the top legal representative of every single jurisdiction in the entire country.
You do.
But why? Like, why on earth does the Attorney General of Prince Edward Island care about a federal immigration law?
It's a fair question. It's because in Canada's federal system, striking down a federal law often creates massive shockwaves that impact the provinces.
Oh, I see.
Like, think about it. If 30,000 refugee claimants suddenly have their status altered, it's the provinces that bear the immediate burden of providing housing, healthcare, social services, all of that.
Ah, okay. So the law dictates that every province has a right to intervene in the lawsuit if they feel their interests are threatened.
Exactly. But practically speaking, for a paralegal managing 100 refugee files at once, this means generating 1,400 perfectly addressed, physically tracked courier packages.
1,400. And the handbook stresses that if you miss even one of them, like if the courier loses the package to the Yukon, or you use an outdated address for Nova Scotia, it doesn't matter how brilliant your constitutional argument is.
No, the court is legally barred from ruling on the charter issue. Your client loses.
Which is why the manual includes that fascinating operational tip. I love this part. The legal clinics actually coordinate with each other.
Yeah, the master list.
Right. They maintain a single, heavily guarded, perfectly updated master address list for all 14 AGs. They share the administrative load because a single typo on the address for the Attorney General of Saskatchewan could accidentally doom an Iranian refugee's entire case.
It requires a level of administrative perfection that leaves absolutely zero margin for human error.
And you'd think, once the paperwork is filed, the binder is perfected, all 14 AGs are served, the hard part is over, right? You've beaten the bureaucracy.
You would think that, yeah.
But surviving those deadlines actually triggers an even darker threat. Because filing a lawsuit against the government creates a permanent, searchable public record.
And for an Iranian refugee claimant, a public court record is not just, a minor privacy violation. It is an immediate physical danger.
Yeah, and here's where it gets really interesting. Because we don't usually think of mundane Canadian court dockets as instruments of foreign intelligence.
That they are constantly monitored. The confidentiality handbook is very explicit about this. The Iranian government actively conducts surveillance on its diaspora. Wow. They scrape foreign court records, immigration proceedings, social media platforms, everything. You have to remember, the very characteristics that make someone an Iranian refugee, whether it's political opposition, women's rights activism, converting to another religion, or being LGBTQ+, those things are heavily criminalized by the regime in Tehran.
So if a claimant's full name gets published on the federal court's online registry as suing the Canadian government for refugee status, Tehran's intelligence services can just see that.
Yep, they can see it clearly.
And the manual points out the horrific consequence of this. It isn't just about the claimant in Canada. The family members who are still back in Iran become targets.
Exactly.
They can be subjected to harassment, travel restrictions, interrogation, or even detention, purely as retaliation for their relative claiming asylum overseas.
And this creates a massive friction point in Canadian law. Because our justice system is built on the absolute necessity of open courts, right? The democratic principle that justice must be seen to be done. Secret trials are generally forbidden.
Right.
So how do you balance that foundational principle with the literal life or death need to hide a litigant's identity from a foreign government?
That's a tough one.
In Canada, you have to satisfy a Supreme Court framework known as the Sherman Estate Test.
Right, the Sherman Estate Test. So to get the court to hide your name, you have to prove three things under this test. First, that open courts pose a serious risk to an important public interest.
Right.
Second, that hiding your name is the absolute only way to prevent that risk. And third, that the benefits of secrecy outweigh the negative effects on the transparency of the justice system.
Exactly. And because of the well-documented surveillance risks, Iranian refugees usually pass this test pretty easily. But the mechanics of how the lawyers actually cloak these identities are fascinating.
The handbook actually instructs legal teams to never, ever use the client's real name on any public-facing documents. They use initials, like AB.
Right?
Or, if the initials themselves are too unique and could somehow be cross-referenced, they use a completely neutral pseudonym, like XY.
Yeah, keeping it completely anonymous.
So the public docket just reads, XYV, the Minister of Citizenship and Immigration. And if a law firm realizes they accidentally filed 50 cases last week using real names, the manual actually teaches them how to file an emergency omnibus motion to retroactively cloak all 50 files at once before the surveillance nets scrape the data.
It's like a rapid response team.
Yeah. But wait, hold on. I was wondering about this. If my lawsuit just says XYV the minister, how does the Canadian government even know who they're fighting?
Good point.
Like, how do you legally defend yourself against a pseudonym? The government lawyers need to know whose file to pull out.
Yeah, and that is a crucial distinction that explains how the system actually functions. There is a massive difference between anonymizing the style of cause, which is the public title of the lawsuit, and actually sealing the documents from the opposing party. It's a dual-track system.
Okay, so it's like a bouncer at an exclusive club.
Oh, I like that. How so?
The crowd standing on the sidewalk, they only see a masked guest walking through the door. They have no idea who it is. But the bouncer holding the clipboard, in this case the court registry, and the government lawyers, they have the actual VIP list. They know exactly who is behind the mask.
That's a perfect way to look at it. So the lawyer files all the public documents under XY, but they send a separate, highly confidential cover letter directly to the court registry and to the Crown lawyers. And that letter contains the client's real full name, their date of birth, and their unique client identifier, or UCI. So the court and the adversary have total clarity on who XY is, so they can argue the case fairly. But the general public and foreign intelligence scrapers are kept completely in the dark.
That makes a lot of sense.
Yeah.
But even with that dual-track system, the expert paralegal who wrote this handbook included a very stark warning. Anonymizing the title of the court file is not an impenetrable shield.
No, it is not. The handbook explicitly warns that anonymization only protects against passive public surveillance.
Passive surveillance.
Yeah. It stops a bot that is just passively scraping the court website for Iranian names. But it does absolutely nothing to protect you against an adversary who already knows who you are and is actively hunting for your specific case.
Wow, that's scary.
And furthermore, human error is always a factor.
Of course.
If a lawyer successfully titles the case XY, but accidentally leaves a specific identifying detail in the body of an affidavit, say, the exact date of a highly publicized protest the client organized, or, the specific department of the university they were expelled from, that information remains public. Tehran's intelligence analysts can easily piece those clues together.
And the digital footprint aspect is terrifying. The manual mentions search engine caches. Like, if you filed the case under the client's real name on Monday, realized your mistake, and got the anonymity order on Wednesday, Google might have already cached that original public page.
Yep, it lives forever.
Right. Someone searching on Friday might still find the real name lurking in the search results. It requires meticulous, constant vigilance. Every single document has to be scrubbed.
But against all odds, they actually pull this off. So let's fast forward.
Let's do it.
The legal team has hit the 15 days. They coordinated the master list for the 14 AGs. They beat the bureaucracy. They successfully cloaked the client as XY. And they tucked them safely in abeyance behind the lead cases. And now they just wait.
Right. 4, 5, maybe 7 years later, the Supreme Court of Canada finally issues a ruling on the constitutionality of Bill C-12? What actually happens in the endgame?
Well, the procedural guide outlines the realistic outcomes to this constitutional war. And it's rarely a simple you win or you lose.
It never is it?
No. Obviously, the challenge could fail completely, in which case the abeyance ends and the clients have to try a desperate last-ditch effort to avoid deportation.